Welcome to Looking at Legal Stuff. Today we have 9 hearings in a case with a couple where mom is asking for changes to the temporary parenting plan now that they have the GAL report that they've been waiting for. Dad has had issues with substance abuse and following mom to film her, which led to a domestic violence restraining order and a temporary parenting plan that restricted Dad's visitation. Mom is asking the court that he be required to complete his DV treatment and parenting classes while Dad transitions to having more parenting time. She also wants to continue to have a third party exchange the children because things have been going well doing it that way, but she'd be willing to exchange them directly with Dad when the DVRO expires, so long as Dad has done everything asked of him. Let's see what the judge thinks.
Thanks for drafting that on short notice too.
All right, next I have the Pedersen matter, 22-3-39608. There we have Ms. Baldwin representing Lacey Pedersen and Mr. Fuel representing Thomas Pedersen. Ms. Baldwin is present, Mr. Fuel is present, Ms. Pedersen is here, Ms. Height is here, and Mr. Pedersen is here. Let me just pull up my notes and we'll go ahead and get started. Okay, I have those notes in front of me. I did review Ms. Height's guardian ad litem report. Thank you for submitting that. I appreciate your efforts there. So I've read over that and I've read the pleadings that have been submitted by the parties in relationship to substances and in particular dextromethorphan, I believe is how you pronounce it, and the substance use disorder treatment that Mr. Pedersen has undergone and the like. So I've also reviewed income information that's been lifted up just recently. So I'll hear from Ms. Height first, if you have any comments to lead out, and then I'll turn the time to the parties.
Thank you, Your Honor. I do have a few things to maybe illuminate my report a little bit. I spoke with providers Tucker, Johnson, and Lovely subsequent or during the filing of this report and have a clarification and information that made me comfortable with what I had already put in my report without their written reports to me. I felt like what I heard from them was accurate and what I included in my report was accurate. I do have I don't know if it's really a concern. I guess I'd like to just offer it as a clarification for Your Honor. I don't want to minimize the concerns that have been brought forward by Mother in this and the way that she feels. I also don't want to overreach in providing relief or security for Mom in a way that creates a negative impact on the kids as far as their relationship with their between the children and their dad. I would like to just remind the court that there has never been allegations of domestic violence or of any kind toward the children. So I didn't really have any concerns there. I guess the core of my concerns are that behaviors by Mr. Pedersen have been identified by the professionals as stalking and domestic violence. And those seem to conjure up much more dangerous effects than what I'm seeing in this report. Well, I understand that's kind of the clinical designation that need to be used. When I spoke with Ms. Lovely and read her report, she also agreed that calling this stalking and domestic violence may be an overreach verbally, but it fits in the clinical approach that she took. She agrees that the domestic violence treatment that she has recommended and that I have recommended really will lean more into boundary work for him rather than kind of a standard domestic violence that might be thought of by the court. So I guess I just want to soften those words a bit for Your Honor as to what I am thinking here.
Thank you, Ms. Height. I appreciate that softening. So let's hear from the petitioning party, Ms. Baldwin, and then Mr. Fuel.
So first off, we're only here to review the guardian ad litem report. And the report's been filed and it's before the court. Courts and different members of the bench take these hearings differently. Some say the only purpose is to review the report. And if you want to change the existing plan, someone should file a motion, and then everyone should have an opportunity to fully respond to that motion before we go forward. And in this case, there's also the sort of late breaking psychological report. We only received that a few days ago. That was filed. And so that's another concern, is that my client really hasn't had much of an opportunity. It looks like it was filed, and now I can't say that it was filed, but it's signed March 2nd, which would have been Thursday. And as Your Honor is aware, I was in trial Thursday, Friday. So we haven't had an opportunity to respond to that. That psychological report has a number of sort of red flags that my client would like to better address and flesh out for the court, sort of her concerns around that report. And so if the court's considering making changes to the temporary order, at least the temporary parenting plan, we'd like an opportunity to be able to respond to that. And so we would ask the court set this matter out at least 2 weeks so we can respond to that psychological report at a minimum before we make changes. Similarly, we're not on to address financial matters at all. Counsel sort of attempted to bootstrap that in, and that just isn't what we're before the court, no matter how you slice it, to address those issues. So if we're going to address those issues, those should be required to be via a motion. So those are my requests, is that we set the matter out, give my client an opportunity to respond to those late breaking items that are somewhat impactful. There's a number of red flags in that psychological report that would indicate cause for concern. Again, my client doesn't want to keep the children from the respondent, but she does feel that it's important that we have a safe, logical, sane way forward that leaves those boundaries intact.
Thank you, Ms. Baldwin. Mr. Fuel?
Thank you, Your Honor, which is exactly why the court, I presume, ordered a guardian ad litem. I certainly am at a bigger disadvantage in this court than Ms. Baldwin. I'm sure she's correct. I know that my experience throughout the counties I more commonly practice in is that some courts will require a motion and some won't. I think Ms. Height really nailed the issues at hand, Your Honor, and clearly in her report she dealt with and absorbed all the professional aspects of this case. I don't know that kicking this thing out a couple of weeks to make changes makes a lot of sense, other than just delaying the inevitable. If the court is considering that, I would ask that the court go ahead and implement parenting time now on maybe a 2-week or interim basis until we come back. Certainly, Ms. Height is qualified to make a recommendation. She again reviewed everything. In fact, our position would be that because it seems pretty conclusive by all the experts and our guardian ad litem, and as Ms. Height brought to the court's attention this morning, that this is not a domestic case as the court normally is concerned about. I came in late, so I don't know to the extent that this court is familiar with what the allegations are. Certainly, the record seems like it's probably pretty clear, but we would, if the court is going to go ahead and make some modifications to this parenting plan, whether, like I say, interim or as a new temporary parenting plan, we would like to be heard on refining some of the recommendation points that Ms. Height made in her recommendations. And so if the court is interested in hearing those arguments, I'd like to make them, but I guess I'll let the court respond.
Okay, thank you. So I guess my general approach to GAL reports, once they're filed, GAL reports will strike different parties in different ways, obviously, when the recommendations are made or factual assertions are brought forward. So the GAL brings those forth, lays them out on the table in front of everybody, and everybody gets to pick up particular cards and they get to flash those around and argue which ones they want. So in my mind, when a guardian ad litem files their report, it's fair game. The issues are there before the parties, and the court's read that, the parties have read that, and so then everybody's apprised with the backstory and also the new information from the GAL. And so the issues are on the court's table, if you will, to decide. So that's just in general. The Dr. Johnson's report, while it has not been formally filed or penned, at least I don't think I've seen that. There were some initial recommendations or information that Ms. Height had shared in kind of thumbnail form. And it sounds like that report has been formally finished as of March 2nd, and there was some additional information that Ms. Height provided on that to the parties. I tend to agree with the parties that with Ms. Height's rendition of the domestic violence tag that's attached here, the allegations are that there was either a single day of recording or a period of months of recording. There's no indication that there's been violence towards the children in the traditional form of hand to backside or hand to a swat to the head, or violence in the physical violence of like holding or restraining or punching or kicking of the other adult in the marriage. So that we don't have that. Domestic violence can be broadly defined and narrowly defined, and here there's a clinical rubric that Ms. Lovely has works with and has worked for a number of years, and that it fits within that clinical rubric of domestic violence. I appreciate Ms. Height's kind of clarification or putting words to that of maybe boundaries. Boundaries are an issue, and domestic violence is about control, and control relates to boundaries. And so I can see why Ms. Lovely may, with her expertise in domestic violence, would classify it as such. Because there are the information with from Dr. Johnson isn't fully fleshed out. At least I haven't fully been apprised of the full report. That I think it's important that we have that opportunity to review that in 2 weeks on the 21st of March. So I'll grant the continuance for that purpose to look at that, because the guardian ad litem does make recommendations as to parenting plan and holidays and the like. There's recommendations related to SUD and contact issues, exchanges, and SUD and dextromorphan, if I pronounce that correctly. So there's a lot of issues that are there, and I think also even the issues of the substance uses, including alcohol and cannabis, that's on the table. There's a potential. I think we need to probably address potential issues as far as incomes. With an indication there's an indication that the father's indicating his salary is fairly set, and there is some bonus, but it's a fairly low level. And that there's an indication that, at least from his perspective, that the mother's income does not reflect any bonus monies that she may have received. And so I don't know if 2 weeks is going to be enough for the parties to address those issues. I think it will. And there's also issues of spousal support. And I think the spousal support, that needs to be a separate motion that's brought because it's not necessarily brought up. And I think the child support, I guess, the guardian ad litem report doesn't really address those particular issues. So there's kind of these issues that have been raised by Mr. Pedersen, obviously of a concern to him. But I think if there's a motion, it would be appropriate to have a motion for child support modification and spousal support modification. I think that's a cleaner way of approaching it, because here we're on a guardian ad litem final report, which of course touches upon those issues, but indirectly. So there would need to be separate motions for that. I know that there's been information filed at this point that the court's been apprised of, and then we need to hear the other vantage point. So that needs to be heard separately. And if parties can have it noted up within 2 weeks, great. If that takes a little bit longer, then we'll address it once it gets ready.
So I guess it's a little bit on Mr. Fuel. 3 weeks is what the current local court rules say. That would take us to the 28th if he filed his motion today. I'm happy to, if he files his motion today, address everything on the 28th, or if he wants to just run it separately. Both are fine with me.
And Your Honor, I'm going to ask the court if the court is indicating that we're not going to budge on a change in the parenting time pending the next hearing, then we want that next hearing as soon as possible, because obviously the parenting time is really the 90% of what we're talking about in this case. And so if the court is considering not giving my client any expanded parenting time in the interim, then we want that hearing to be as soon as possible. However, if the court is going to give us some interim parenting time to match the recommendation of the court-ordered GAL, we would ask, what we can do is go ahead and I can cite the modification motion on along with with this review on the 28th. At least I believe at this point, like the court mentioned, I think everyone here at least understands the position of Mr. Peterson on this issue. So I know that there's not a notice issue, although I do appreciate that there's a sort of a pro forma procedural issue that we need to resolve.
Okay. Okay, so we will set this matter over to the 21st to address the parenting plan issues raised by the guardian ad litem report. And it sounds like the other issues of child support modification and spousal maintenance will be cited on, and that'll probably be in either the 28th or first part of April. So we'll look for those citations to come through, and then we will see everybody on the 21st to address these important issues.
All right, very good, thank you.
Your Honor, just for the record, I did file the Johnson report, but I am guessing that it's en route to the courthouse in your honor.
I think that's an accurate rendition. It's in process. Yeah. Yeah, and that'll allow that to be received and reviewed fully. So I think that's probably good too.
Okay.
All right. Any last issues, Ms. Height?
No, Your Honor.
Okay. All right. With that, thanks to the parties. We'll see everybody on the 21st.
Thank you.
Thank you, Your Honor.
So then let's take a look at, let's see, the Pedersen matter. That's cause 22-3-396-08. Ms. Baldwin represents Lacey Pedersen. Mr. Fuel represents Thomas Pedersen. Ms. Height is the guardian ad litem. I see Ms. Pedersen is on the line today. Ms. Baldwin is here. Ms. Height is here. Mr. Fuel is here. And Ms. Height is here. So let me get everybody on at least on my left side of the screen so I can see everybody. And Mr. Thomas Pedersen is also here. So everybody is present. Okay, so, all right. Thank you for your patience with that. We have here parenting plan issues that are to be presented and resolved today. That's my understanding of why we're here today. So we had Ms. Height. She submitted her guardian ad litem report with lots of information and some ideas and recommendations and suggestions. And then we have some feedback from the parties on that. Also, Dr. Johnson's report was submitted and that's been reviewed. And there was one recent declaration that I've reviewed by Ms. Pedersen. So I just want to make sure that everybody knows I'm up to speed and have reviewed all the documents that have been submitted. So I'm not sure who wants to go first. Ms. Height, you provided your report. Your report says a lot in and of itself. So I don't know if you want to have any other comments in addition to your written report.
I think at the present time, Your Honor, I'll stand on my report. Thank you.
Okay. All right. Thank you. Ms. Baldwin.
Thank you. So again, for the record, I represent Lacey Pedersen. We're here just to address the parenting plan. So essentially, the court had entered a temporary parenting plan, set forth a guardian ad litem, and this is the time set aside essentially to review that temporary plan in light of the guardian ad litem's report. In looking through the guardian ad litem's report, I don't think my client's requests are that far from the guardian ad litem's recommendation. It's essentially her recommendation with a couple important changes, but those changes I think are appropriate. The court should maintain the domestic violence finding at 3A. That's an issue, essentially issue preclusion. That's appropriate. The court should reserve other findings. This is a temporary order. My client should have an opportunity to present those issues at trial. There's a fairly substantial amount of evidence that can be presented in this case and has been to some degree already. As far as limits, the court should have appropriate limits and requirements as largely recommended by the guardian ad litem. That is that Mr. in this case be required to complete domestic violence treatment with Olivia Lovely, continue in any personal counseling he's engaged in, and complete the children in between class. I believe my client's already completed that. I'm not sure if Mr. has in this case at this point. We're also asking that the court specifically have a prohibition against smoking illicit substances or marijuana and alcohol at least while the children are present and 12 hours before, at least as to Mr. That is appropriate. There is a lot of documentation in this case. That prohibition should also include a prohibition on the use of dextromethorphan or DXM, because that can be abused as a substitute when people are trying to not test positive for alcohol. They then choose a substance that they can get over the counter and then abuse it. The concern here is that when you look at the UAs that are included, even the substance abuse treatment provider indicates in theirs, this isn't a substance he has an authorization for. They're indicating no compliance in those UAs. And the concern here is that his story changes, which tends to be fairly typical of somebody who actually does have a drug and alcohol problem. Initially, it's, oh, well, I had a cold. And then it's, well, no, really, I had this other issue. And then finally it settles on, well, I really had an earache. But that doesn't really make sense or line up with the use of this drug. And there are many other over-the-counter treatments that you can use that are not this drug. It also doesn't make sense that when you look at the extended period of time that this drug remains in his system for months and months and months. That's not an acute illness that you're taking it for. That looks a lot like addiction. So again, there's many other substitutes that are not addictive. And so we're asking that in this case, because that is a question and a problem, that he be prohibited from use of that. As far as decision-making, although there is a domestic violence finding, my client is agreeable to joint decision-making. These are not children with very significant issues. But my client should be allowed to make all the standard well child checks, vaccine appointments, dental cleanings, sort of without input, because no input's really required at those types of appointments. But if something significant happens, mother to inform father at that point. But that she sort of, as primary parent, will take primary responsibility for taking care of those sort of maintenance appointments. As far as the schedule, that's sort of the main issue that parents tend to have before the court. We're asking that the court adopt a first, third, and alternating fifth weekend for the fathers, but that should slowly progress over the next 3 months. Father's currently doing day visits, and so my client is a recommendation that for the first month, Saturday at noon to Sunday at noon, the second month, Friday after school to Saturday at 6. The third month then would be sort of off into the regular schedule of Friday after school to Sunday at 6, as recommended by the guardian ad litem. That allows for a reasonable transition plan. And again, as my clients indicated, these children really haven't had extended periods with their father. That allows for a progressive, reasonable build-in. As far as holidays, my client's largely in agreement with adopting sort of a standard holiday plan. Spring break, which is in 2 weeks from now, my client's asking simply that we hold off on spring break until next year. And then spring break should be divided in the middle, with the parents exchanging on Wednesday. As far as the summer schedule, my client's asking that the court limit the parties to one week this year. Mr.'s never had more than 2 overnights with the younger child. The older child has had a week, but struggled with it and really had a hard time. And that hard time is probably more significant now, based on where the parties are now compared to when that child had that one extended period. So my client's asking that be limited to 1 week until we get to trial. In this case, the exchanges are the other significant issue. My client's asking, currently they're exchanging the children at Fred Meyer in the parking lot. Mr. is having his family do the exchanges. That's working really well. It abides by the domestic violence protection order. It also allows for a stress-free exchange, an exchange that is having no issues and is appropriate. We're asking that that continue at this point, and that essentially be the carrot and stick with completing the domestic violence treatment that's recommended by the guardian ad litem. If he does that, about the time he completes that treatment is about the time the domestic violence protection order would roll off. Those would happen fairly close in time. And when those do, at that point, then the parties could exchange directly. But it is important that my client not be in a position where she's required where both parties were being required to violate the domestic violence protection order. That is not appropriate. In this case, I think the guardian ad litem missteps and sort of makes a statement that's kind of well, I want to redefine domestic violence. None of us are kings here. None of us have that authority. The legislature sets forth what domestic violence is. In this case, there was a lot of briefing that Your Honor reviewed on the specific law around domestic violence because it has changed recently. And so in this case, it's appropriate. My client does have the domestic violence protection order that should be abided by until it expires. And again, until Mr. completes the treatment, that is the boundary setting that's critical. I think everyone here, when you look at the documentation, it's clear that Mr. Pedersen has an issue with boundaries. Those types of issues do not disappear overnight. It's not, oh, I was called on it, so I'm fine, and now I know. Those are issues that are ingrained and that take time to resolve. So people understand that boundaries are important and they have to be abided by. So in this case, it is appropriate. It's appropriate that we allow my client to have the protection order that she has and to not essentially undermine it with the transportation. That's especially true in a case where right now the transportation is going well, it's effective, it's efficient, and it's safe. And that allows that boundary setting to be well established before the parties move to direct exchanges. Communication should continue via our family wizard, that's currently working well. It should be limited to significant issues of the children so that we're not discussing shoes or backpacks or those types of things. And that is a reasonable request. So in this case, my clients made very reasonable requests, very reasonable small changes to the guardian ad litem's recommendations. They're all in the best interest of the children. It's not in the children's best interest to violate or undermine the domestic violence protection order. It's there for their protection. That's why we have these findings, is these findings are helpful to the court and helpful to ensure that we have a plan that makes sense for these children. So we're asking the court to, again, largely adopt the guardian ad litem's recommendations just with those small changes.
Thank you. Mr. Fuel?
Yeah, Your Honor, just real quick, since Ms. Height was specifically called out in that argument, I don't know if she wants to address that first.
I'm fine with that too.
I understand those comments, and I'm not setting myself up as someone who's going to undertake to change protection order. My comments and recommendations within my report, I believe, are in the best interest of the children. I just feel like when I said that it appears that it's, I guess I would say it's bad optics to treat father as if he is dangerous in a parking lot at Fred Meyer. And that was really my thinking in that regard. I do understand the court's ruling, but that was my thinking in that it is probably in the best interest of the children to see these parents behaving civilly. And I hope that can happen down the road, if not right now.
Thank you, Ms. Height. Mr. Fuel?
Yeah, thanks, Your Honor. So just real quick, I know the court has information on the medical concerns that Ms. Baldwin raised. Obviously, the one thing that none of us have here is any sort of expert information for the court regarding the specific drug issues that were raised. I think it's pretty relevant that all of the experts that were appointed and used by my client on court order all support the idea that these are not actual issues, probably ever, certainly not now. I also think it's probably more important than what none of us have met up in Olympia, think of domestic violence as to what our court appointed experts and or voices that the court relies on all the time don't feel that this is specifically a DV circumstance that the court is certainly aware of. Obviously, we've all had cases with real domestic violence. And again, I appreciate that there's some dispute between the parties and everyone's not getting along. And there is certainly a DVPO right now. But I think that those issues are largely dealt with the recommendations in the JL report and with all the other expert reports the court has relied on. I think it's probably reasonable to reserve on the 191 factors. I don't think that there's probably beyond the technical finding, or at least the technical determination that in the Lovely report, but for that and the existence of the DVPO, I appreciate that those are relevant factors for the court to make a decision on. However, given all of the weight of the other people who the court is relying on, that it's probably best to reserve on any 191 factors. I don't think there's a basis for any limitations. I think that that the court simply puts in the order that both mother and father will follow the recommendations of continued, counseling for mom, counseling for dad, children in between. For both, sounds like mom's done that. I'm not sure about my client. I know we've been going through a lot of information here. I think it's telling that the recommendation is joint decision making. I think that speaks for itself. I don't think we need special language around what kind of joint decision making is going to exist. Obviously, father has there's no reason why he should be limited in that content. Although I do appreciate there are some limitations as to how that contact will occur. Regarding the parenting plan specifically, Your Honor, again, I know this is before the court, but just as a reminder, my client does have a flexible work schedule between when he has to go into the office, remote work being available, significant PTO, so he is largely available. We think the court should keep that in mind as it creates a parenting plan with the weekend, spring break, holidays, summertime, etc. First, third, and fifth makes sense. That was obviously in the JL report. We'd actually push in the opposite direction of mom, which I guess is probably not a surprise, but we think not only should these weekends begin immediately, full stop, but we think if the court is going to be considering any sort of expansion, that this should really look more like a Thursday afternoon, Thursday after school to Monday morning alternating weekend. I mean, my client at this point has been without significant time with his kids. And again, I know that the court has to operate on the information it has as it goes, but in retrospect, I think that based on Johnson, Lovely, JL report, that largely the concerns that this court was relying on when it significantly limited my client's parenting time don't exist. There's certainly, if they do, they've been addressed. I know my client is, the DV class that's been recommended. He's already started that with Ms. Lovely, and that's a thing. We appreciate that, but this is a parenting plan that should have probably not ever been implemented to the extent that it was, and should be expanded as rapidly as possible. This spring break, I do appreciate that it's right around the corner, and that puts the court in a bit of a jam. But the recommendation is 50-50. If we're going to alternate in the years, in the upcoming years, maybe we split this one on Wednesday, midweek. Each side gets half. Going forward, again, when we're getting to summer here real quick, I think that at the very least, the court should give my client a full week each month of summer. So a week in June, a week in July, a week in August, if not a full alternating weekend schedule. Again, I know that's probably ambitious given where we are, but I don't know that there's anything on the record that supports any concerns or limits between my client and the children. I know that, again, we've got a DVPO and there's some disagreements between mom and dad, and that's fine. Those things happen, but these kids need to be getting reasonable contact with their dad. And at this point, I'm not sure there's any legit reason to limit that really in any kind of capacity. We'd also just specifically, Your Honor, I'm not sure these were addressed in the JL report. So just if Ms. Height wants to weigh in, we would like as much digital contact, whether it be phone or text, email, what have you, with the children. Granted, the younger one's 3. I get that that's not really likely a thing to much of an extent, but the 13-year-old or 14-year-old, obviously, contact with her, I think, is really something that is going to be supported by the JL's report, and also to the extent that the court needs to put this in the order, which probably does for the sake of simplicity. I know from my conversations with my client that the older child does have some extracurricular activities. I think she's in orchestra and plays volleyball. We'd like it to be clear that my client is allowed to attend those activities without limit. Obviously, well, with limit under the DVPO, obviously no contact with mom if she's there, what have you. But again, there's not any sort of supporting evidence, I don't think, to limit his contact at all with the children. He should be allowed to go to those activities, if not just for himself, but for the kid to know that dad is interested in her activities and what she likes to do. All right. I'll leave it at that for now, unless the court has questions.
No questions. Ms. Height, do you have any input?
Thank you, Your Honor. I do think that some limited video contact might be appropriate. I also know that sometimes that can be troublesome with various schedules of the kids and so forth. I think setting a specific time might make sense for these kiddos to have a chance to talk with their dad. And yes, really, Peyton is probably the only one of the two that could really get any great advantage to doing that. So if the parties or their counsels could decide on perhaps a midweek visit by phone or by video, and let the length of time be kind of driven by Peyton. If she's in a talkative mood, it could last however long she wants, but if 5 minutes is all she wants to talk, then there shouldn't be a certain prescribed amount that she's got to talk to her dad, because kids have other things going on and other interests day to day. But I think that would be appropriate. It would be good for Ellie also to at least see her dad and hear his voice. I think it would be good contact for them. As far as attending the sports, I agree that boundaries have been an issue, and that is really what he's working on, what Mr. Pedersen is working on with Miss Lovely. I think going to sporting events, if that would not cross legal boundaries, would give him a perfect opportunity to demonstrate that he is learning and that he can maintain boundaries, that he can get contact or not contact that is appropriate at those events. And I think that would certainly be good for the kids to see their dad there. I also agree that a long time, I don't really know if for the children's safety, a long ramp up to the visitation schedule is really necessary. As has been stated here, the conflict that brought us here really is a thing of the past, and there never was any danger to the children that I could find. So I feel like waiting and lengthening the time of getting back into some kind of regular schedule is probably not necessary at this time. And I do believe that having spring break half and half would work for the kids at this time.
Thank you, Ms. Height. Ms. Baldwin, your rebuttal.
Thank you. So it's important, even if we were to sort of set aside the 191 factors in this case and the concerns of this case, the court's sort of underlying job is to look at what the parties historically have done and what historically their involvement has been. And in this case, Mr's involvement was such that he had never had the younger child more than a few nights on his own during their entire relationship. And that his relationship with his older daughter, who's 12, he struggled to be able to manage her emotions on longer visits when he was without my client. So that's the underlying relationships that the court is balancing. And so it's important that we look at what the children need and what's appropriate for them. The concern about the transportation that's an adult concern and not a child's concern. Grandparents pick up children all the time for various reasons. My client hasn't explained other than your grandparents are picking you up. So currently that's working very effectively and efficiently, and especially during a time period where Mr. Pedersen is sort of retraining his brain to understand boundaries. What we don't want to do is immediately start breaking those boundaries again, and that be what the children witness, is that boundaries don't matter and that we're in a position where boundaries shouldn't be respected. That's certainly not something that we would want to teach a 12-year-old girl as she's starting to move on into the middle school and high school years. I'm concerned that counsel sort of says, oh, well, this isn't real domestic violence. And again, that's where I say none of us are king, and that includes counsel. We don't set what the legislature tells us domestic violence is. We take our direction from that. So in this case, we do have that finding, and it's based on a pattern of evidence where Mr. Pedersen was not just mildly violating boundaries, but doing things that were fairly significant over a protracted period of time. And again, that's going to take time for him to learn that those behaviors are not appropriate. That's not something that goes away instantly. Addressing digital contact. The children we have one child that's very young, in the sort of toddler preschool age, and we have a child that's 12. I generally, for older children, will say it's the child's right to contact father. That doesn't violate the DVPO. It keeps it sort of separate. It allows child to reach out and have the contact that they want, sort of without my client's interference. That would be the most appropriate for that child. As far as the younger child, that's a little bit more of a delicate balance. I would ask that be no more than once per week and very time limited. Again, we're dealing with sort of a preschool age child. And those are, again, because we have a case that has specifically digital stalking, these are the types of things that can be used for that purpose. In that you're allowing a window into the other person's home on a consistent basis. You're allowing a place where mom has to be in a place where she's receiving the information, allowing, essentially having a Wi-Fi connection, being in a place that allows that, allowing for that tracking. So again, there's some concerns there because we have that history and pattern that's concerning, that is the underlying pinnings of some of this case. As far as the sporting events, again, I think that that's somewhat dictated by the DVPO and the size of the venue. So I think we should just allow it to rest essentially in the size of the venue. My client's suggestion is not a long ramp up, it's 2 months. It's by month 2, essentially we are at the full request of the guardian ad litem. So that is not a long ramp up, it's a short one. And again, spring break, we're at spring break in 2 weeks. Spring break essentially starts April 1st. And so I think it's not appropriate to engage in spring break this year. Next year is a different story, but I think this year where we are and what the children need would not indicate that spring break would be appropriate. Summer, yes. But when we get to the summer months, again, based on these parties' history, a week was a challenge for the older child. And so that would indicate that a single week during the summer for this year would be appropriate.
Okay, thank you, Ms. Baldwin. All right, so something that I noted that was important to lead off with is that Ms. Hyde made an observation about the 2 children involved, the 3-year-old and the 12-year-old, or the 3 and the 13-year-old, are doing fairly well. They're weathering this difficult time significantly and substantially well, and she attributes that to the good parenting of both parents. And I think that's a tribute, and I think that's important, especially in times of divorce and dissolution, that sometimes those positive things get lost in a lot of other conflict. So kudos to the parents for whatever you're doing that are helping and supporting your children. So that's much appreciated. So just a few observations. The issue of domestic violence. Domestic violence is certainly a spectrum. It could be as far as infliction of stab wounds and shootings and physical violence with fists and feet, and it can be physically very, very, very ugly. Emotionally, domestic violence it manifests itself, and certainly that occurs on a spectrum also. Here, Ms. Lovely, a certified domestic violence evaluator and treatment provider, has deemed that domestic violence exists based on a finding of stalking. The stalking is related to surreptitious recording of the mother, Ms. Pedersen, and Mr. Pedersen indicates from his view that it was a one-time event related to conversations with the older daughter. Ms. Pedersen counters that it was occurring for months. So there's some disagreement there. So I'm going to keep the DV finding in place. And then Mr. Pedersen will just finish out the domestic violence treatment classes that he's going through and learn and make changes related to sounds like boundaries is kind of the main issue. And I don't mean to diminish or lighten the importance of boundaries, because obviously boundaries are certainly important, but on the spectrum of things, it's certainly if the right side of the spectrum was the extreme violence, emotional and physical, Mr. Pedersen's case would not cross the midline, in my estimation, of that spectrum. So I also note on Dr. Johnson's report, he indicates that from his evaluation that Mr. Pedersen is well functioning and he's generally adaptive with no major personality disturbances, and that there's no signs or symptoms of a major mental disorder or serious emotional disturbance. And then he also concludes that there's no psychological disorder that would interfere with Mr. Pedersen's capacity to act competently in a parenting role. So certainly there's concerns expressed by Ms. Pedersen related to her former husband or soon to be former husband related to that, but on a kind of a psychological evaluative process, there's no concerns from Dr. Johnson's viewpoint. So having said that, I know that there's been a period of time where the parenting role of Mr. Pedersen has been significantly limited. From my view of the evidence prior to that the parties were significantly involved with the children. I'm not exactly sure what the division of responsibilities were, but both parents were involved in parenting the children. And I note that Mr. Pedersen adopted Peyton, who's now 12, and that was some time ago. So I think that warrants, at least in my view, that we will start immediately with the first, third, and fifth weekend visitations for the father. There's no reason to delay that. That'll be Friday after school. That'll be this Friday, and until Sunday at 6, and that'll be on the first, third, and fifth. And now that I say that, I better make sure that this weekend is the first, third, or the fifth. If it's not, let's go with the first, third, and the fifth. So just for clarity and consistency. So I don't think the tiered approach is necessary, and so I'm not going to order it. As far as the spring break, the same rationale applies, based on Dr. Johnson's report and the like. So that'll be split the spring break in half, with the mother's first half occurring the first portion of the week, and the father's half occurring on the Wednesday afternoon exchange for the second half of the spring break. Please note that I am going to add language in the parenting plan, please, that indicates that no cannabis or alcohol be used by either parent when supervising the children during the supervision and also 8 hours prior. So the issue of see if I can get this pronunciation correct, dextromethorphan, or DXM. There was indications from October through the end of December that there were, and I don't know if they're high levels or not, but there were levels present in Mr. Pedersen. The doctor's report that the treating physician of Mr. Pedersen almost had kind of a dismissive tone to it. He said, look, this person is taking an over-the-counter drug and he sees nothing wrong with that. And just so that there's no confusion or no concerns, I'm going to give him a prescription. So it almost sounded like the doctor was saying, get off this guy's back. I'm no expert on DXM, and I know almost any substance can be abused. Sugar can be abused. Caffeine can be abused. So there's plenty of things in life that can be abused. because there is that a prescribing physician has indicated that Mr. Pedersen can take that, then that doctor is reasonably assumed to be competent. Then I'm not going to place any limitation related to that, but it'll be related because there has been kind of what I'd call a historical view. There was the negligent driving back in high school, I think it was, with Mr. Pedersen, and alcohol involved. I think the alcohol and the cannabis do need to be part of the parenting plan related to some limitations during his time with his children. I think that's in the best interest of the children. I also note that Mr. Pedersen's been compliant with his treatment, and I believe he completed his substance use disorder treatment. And that was the end of January, mid-January. The exchanges, the concern there expressed by Ms. Pedersen is that there's been issues with boundaries, and boundaries have been crossed in the past, and there's been boundaries crossed with even the exchanges with Mr. Pedersen being off in a distance and observing or what have you. I think the great potential danger for boundaries has been significantly limited by the fact that the parties have now separated. So the fact that the exchanges are occurring via grandparents, I think, is an artificial barrier. I think that the children can transport themselves from car to car at Fred Meyer at a reasonable distance. I'd probably say, park side by side so the kids can get in and get out from one car to the other and not be subjected to traffic by walking too far of a distance. So I recognize that that's concerned. The fact of the matter is, there was a lot of arguments said that, look, the court is kind of going back on itself and is being willy-nilly. The fact of the matter is that DV protection order indicated that the family court would have the jurisdiction to amend that DV protection order. And as we know, DV protection orders there's not a significant part of court time that goes into making those decisions. Here with the family court, we've had insight from the guardian ad litem, we've had insight from Ms. Lovely, we've had insight from Dr. Johnson. So to say that the court is willy-nilly changing this and is going back on the principle of certainty, I disagree. I think that we're in a better position to make a decision on that DV protection order. So the DV protection order is in place until November. However, this court has the authority to carve, if you will, exceptions to that. And I think the exchanges is one, and I think that's proper, and the father can be present for those exchanges. Obviously, everybody's going to be watching close to make sure that there's no concerns related to that. The DV protection order is still there, so that there are those protections and there are boundaries and there are limits. It's not a limitless exchange criteria. Basically, the children remove themselves from one car and go to the other car. Related to the phone and video contact, I recognize that 3-year-olds may be little chatterboxes some days and may just clam up and say, I'm busy working on something else, Dad, so I can't talk right now. So, and I recognize also that video conferencing with a small child necessarily involves the other parent, which would be here, Ms. Pedersen. And she has significant concerns about the contact and the limits and the boundaries because they've been violated, and rightfully so, she's concerned. So I think that the children, if they want, they can initiate those phone calls or video calls with Dad at times that they feel appropriate. That shouldn't be unreasonably denied, and that there should be 2 times per week where the father can have phone or video contact with the children. It'll be a reasonable period of time, subject to age and developmental levels. But if the parties cannot agree on dates and times, it'll be Monday at 7 p.m. and Thursday at 7 p.m. So as far as the extracurricular activities, I've heard some people say that, when they were growing up, my mom and dad never missed a single one of my baseball games, or my mom and dad never missed a single one of my dance recitals. That's big stuff. That sends a clear message to a child that their activities, their life is important to the parents, and the parents are supportive of that. So having the father attend the extracurricular activities, as well as the mother, Ms. Pedersen, attending the extracurricular activities, I think that's important because that tells the child that the child is important to the parent, and the parent takes their time and invests it in the child's time. So the father can attend the extracurricular activities. Obviously, those domestic violence protection order provisions apply to the degree that's possible and reasonable. Obviously, 1,000-foot distance in a smaller gym is probably not going to work. I mean, it's probably going to be less than 1,000 feet. So there needs to be some reasonableness to that. Obviously, if Mr. Pedersen were to sit himself down on the opposite row of Ms. Pedersen, opposite row, or divided by a single barrier, something of that nature probably would be inappropriate. However, if it's on the other side of the bench, if you will, on the other side of the court or the far end of the soccer field or what have you, then that's reasonable. But there's not to be any direct communication between the two as subjected and dictated to by the domestic violence protection order. But he can attend those extracurricular activities because I think that's important for these two young ladies. So as far as the more specifics of the parenting plan, mother is designated as the primary custodial parent. Joint decision-making is appropriate. And as far as the request by the mother through Ms. Baldwin that she's to take care of those kind of the routine cleanings, the routine well child, I think that's fine that she sets those appointments, but she needs to provide notice to Mr. Pedersen of when those are so he can be aware. So if he has some information that occurs on his weekend parenting time or his parenting time that's of concern to him, he can share that information with the treatment provider to help the treatment provider provide the best and best care for the children. So we mentioned the first, third, and the fifth weekend. And let's see, as far as spring break, I think I touched upon that. I'm just going over my list to make sure I have everything. It looks like Mr. Pedersen submitted a document that he completed the children in between class had been completed. So that's fine. And then as far as the parenting plan, it should indicate that both parents should continue with individual counseling, and that Mr. Pedersen should complete his domestic violence classes and treatment. I didn't hear any opposition to using the My Family Wizard application. Mr. Fuel, does Mr. Pedersen have any objection to that?
I don't think so, Your Honor. I think that it's probably good to have things in writing.
Yeah. So we'll have both parties sign up for that and both pay their share for that service.
Is that pro rata, Your Honor?
I think there's a flat fee that I think each party has to pay. So each party will just pay their whatever they have to, their sign up fee and their monthly bill. I am going to allow the Ms. Pedersen to request a urinalysis and or hair follicle test of Mr. Pedersen. Just in the back of my head, I have just a little bit of concern about past alcohol abuses and continued marijuana use. That relates to parenting time. Now, the tricky part with that is that the restriction is to not use cannabis or alcohol during the parenting time or 8 hours before. So even though a hair follicle test is requested, it could very well show marijuana. I guess the difficulty is that showing consumption during the period of supervision. So it's probably more of an alcohol type thing that if Ms. Pedersen has concerns that there's alcohol abuses occurring by Mr. Pedersen during or prior to the supervision of the children, then that'll be a tool that she could utilize. If it comes back that there was a positive UA for alcohol within the time frame of the prohibition, which is 8 hours prior and during the supervision of the children, then the father would have to reimburse the mother for that cost. If it comes back positive for marijuana, I'm not going to, there won't be a reimbursement provision for that because it stays in the system for a much longer time. So I think, let me just review my list to make sure if I've covered everything that I wanted to cover. I think I have hit the items that I wanted to hit, and I may have missed some. So I'll turn to the parties if I've missed some. Ms. Baldwin.
So I just want to address the transportation. The court has said sort of parents stay in the car, kids transport themselves. That's not really possible with a 3-year-old. A 3-year-old is still in a like 5-point harness. Both parents are going to have to get out of the car to get the kid into the harness. And the concern is that when we put the parties so close to each other, we live in a very digital world. We live in a world where an air tag can be put on somebody's car. It's very easy to do. So having a sort of a more set distance to manage that, if the card is having them do in-person exchanges, and also the fact that, again, both parties are going to have to get out of their car based on the younger child's age.
Thanks. Mr. Fuel?
Well, we do have the sibling who I'm presuming is going to be at a lot of the exchanges as well. I'm sure that they can figure something out, even if it's just simply dad parks, opens the car to let the child out, maybe reaches in, maybe some language that says the parties don't leave the immediate proximity of his or her own vehicle, something like that. I get the practical concern the council's raising, but I think it can pretty easily be overcome. Maybe again, with no approaching the other person's car. I think that's probably possible.
Okay, thanks. Yeah, I appreciate the concern raised by Ms. Baldwin. So I think that the provisions related to the exchanges should have added language as suggested that neither party shall approach the vehicle of the other party, and they'll stay within the immediate proximity of their own vehicle. So if that means that Ms. Pedersen feels more comfortable parking 4 parking places away, there's, whatever she feels comfortable with. It's nice that the older child, Peyton, is there that can provide some assistance, and obviously getting a 3-year-old, getting them unbuckled and putting them down on the ground, getting their backpack on their back and sending them on their way. That sounds reasonable. So that language should be added to the parenting plan. Any other concerns?
Sorry, Ms. Baldwin, I don't know if you're finished.
Go ahead.
Okay, thanks. Your Honor, and I may have just missed it in my notes, but the GAL mentioned Wednesdays after school until 6 p.m. Is that part of the court's order?
I apologize. I overlooked that. Thank you. So yeah, Wednesday after school until 6 p.m. That's part of the visitation schedule. That's every Wednesday, where the father can specifically pick Peyton up at school. And then there was provision to pick up Eleanor or Ellie at the daycare, and that the exchange would occur later, at 6 p.m. at the Fred Meyer. So yeah, that's part of the order. Thank you.
No, thank you, Your Honor. And then did the court give us a ruling on summer? I'm not sure that I.
Oh, no, I didn't.
In my notes.
Yeah, I think that there's related to the summer that there are 2 1-week periods of summer vacation is appropriate. And I recognize that this is probably comes as a big shock to Ms. Pedersen, and that she was looking for a tiered approach and kind of easing into things. But based on the reports before me, that there's I don't see any dangers occurring. We're in a new normal, if you will. The parents have separated. The children are going to be getting accustomed to kind of a new way of living and doing. So, and I don't see any reason why not to start that this summer. Ms. Hyde?
Your Honor, would the Wednesday visit then begin tomorrow?
Next week.
Okay.
Next week. Thank you, Ms. Hyde. Okay, any other items that I may have missed or clarifications needed?
In Your Honor, one more from me. As you were going through the cannabis and alcohol limitations, initially I thought you said for both parties. Following up, I thought you said just for my client. So I just want to clarify: is that mutual or is that just for father?
I think it just applies to the father. I don't think there's anything in the pleadings that indicated that was a concern related to Ms. Pedersen.
Thank you for the clarification, Your Honor.
Thanks.
And with Your Honor's change or clarification to add the Wednesdays, would Your Honor reconsider the phone calls? That would result in almost daily contact that my client's required to engage in, because then we have Sunday, Monday, Wednesday, we have Friday, we have the weekend. So it's like that's resulting in mother not really having any days where there isn't contact. And so again, and this is still allowing the children to call as much as they want, these are the prescribed calls she's required to orchestrate.
And Your Honor, our position would be that it's appropriate for father to have equal contact, which obviously we're not going to get to right away, but I certainly think that daily contact between dad and the kids wouldn't be a bad thing. However, this does not necessarily get him to that much contact anyway.
So, yeah, I think the 2 times per week is appropriate. If the parties feel like that should be spread out in a different fashion, then the parties can agree to that. Otherwise, it'll be the Monday and Thursday. So I won't make any adjustments there.
And Your Honor, just one more clarification on the digital contact then. Appreciate the framework for the phone call, especially considering the different ages of the children. Is it my client would like to be able to text directly just the older child, since she does have a phone without the same restrictions of phone calls. Obviously, again, that would, if it sounds like from the court's perspective, if Peyton is initiating contact, that's okay. I presume that the two of them exchanging texts in the normal course that parents do would also be okay with the court.
Ms. Baldwin?
So I don't think the court, so sauce for the goose is sauce for the gander. The court shouldn't change its order here either. The children can initiate as they desire. But again, when we're dealing with somebody who has an issue with boundaries, that quickly can become, I'm going to text you multiple times a day, and if you don't respond, then I'm going to, next time I see you, make that an issue of you've got to respond. So if the children initiate and he responds, that's one thing. If he's initiating those contacts, that's something else.
And I think the record's been pretty clear that there hasn't been any concern by any of the reviewing bodies of DV issues with the children. Again, I appreciate no contact with mom based on the court's concerns. That makes sense. I appreciate that. However, when we get into a text response versus an initiating text, because those texts fly back and forth pretty quickly in certain circumstances, I hate for any of us to have to go back and try to determine what was an initiation, what was a response. However, I do think that we have enough again, carrots and sticks already to make sure that my client understands that he needs to be on his best behavior when it comes to any kind of contact with anything happening in mom's household. I mean, obviously, and again, not to relitigate any of this, but he suffered a pretty catastrophic set of circumstances given what is probably a single incident of recording his spouse. And so I think he understands how bad the court's response might be should he abuse texting his daughter. So I think that probably the court can comfortably sit back and allow him to have these texts with his child.
Thanks. Ms. Height, do you have any input?
Again, this can be troublesome and bothersome to send texts back and forth without any kind of regulation. And yet the very use of texting is often very brief. I think it does give father, again, a time to show that he can follow boundaries. And I think if he could keep it brief and it could be reviewed by mother if she has concerns. And well, but she can't talk to him. Just give me a second here to think how this could happen appropriately. Here's what I think might be in the best interest of the kids. They haven't had this sort of contact, or Peyton hasn't had this sort of contact with her dad for some time, or any contact. If after, what if the court did not allow any texting contact until after spring break, and dad and the kids have had some significant time together and they've reestablished some contact, and then at that point dad and Peyton, and I don't kids, a 3-year-old may be able to text at this point in our technical world, I don't know, But if dad could then begin contact, that would be considered reasonable and appropriate after they've had this spring break contact, kind of break the ice, and maybe between the two of them they can get a pattern settled. It should not be hourly, obviously. It should perhaps would not even need to be daily, but I think it would be totally appropriate if dad had been, for instance, at a sporting event, to be able to send a text and say, I thought you did a great job today. It was fun to see you do whatever you did. Have a good day at school. Something along those lines that would be fairly innocuous, but just a way to maintain contact. Does that isn't very clear, but I think it expresses my desire that they would have that contact, but that there would be a reasonableness about it. I do understand that it can get out of hand pretty rapidly when things get going back and forth, and it shouldn't be an all day or frequent type of contact. It will give father an opportunity to demonstrate that he understands boundaries again, which I think is going to be necessary going forward.
Okay. Thank you. I appreciate everybody's thoughtful input related to the text. You know, and we're talking about a tween or a teenager, 12 to 13. Texting is a way of life, and it's certainly a very common form of communication amongst that age group. There's concerns related to boundaries. I think Mr. Fuel makes a good point in that the court's reaction to the crossing of a boundary was sure and swift, and court's not going to take that lightly if that were to something boundary crossing were to occur in the future. So my sense is that after the visits, kind of based on following the lead of Ms. Height, if the visits have been happening, there's this extended period of time over the spring break, and there's a few weekend visits that have occurred, that's naturally going to create connection. When there's connection, usually between two people, there tends to be communication. Things want to be shared. There's follow-up. There's humor that's found in shared activities and the like. That starting May 1st of 2023, there can be moderate and reasonable numbers and length of text communication between father and the older child, Peyton. The 3-year-old will need help, is my assumption, and I'm not going to allow that at this time because that would involve the mother. But certainly Peyton can initiate text messages. The father can initiate text messages. The nice thing about text messages is that they're generally hard to delete or erase. I mean, you can delete them and erase them, but there's still a record on that. You look on your phone bill, you can still see them, notwithstanding any effort to hide them. So I think that's fine. There can be text communication in moderate and reasonable amounts and length between the father and the older girl. Okay, we've covered quite a bit of ground. Any additional items that the parties may have seen that was not covered adequately?
No, we just need a presentation date.
So generally, we want to take a look at a 2-week period. If that the parties feel that that's reasonable, to come back on the 4th of April or possibly on the following week, which would be on the 11th.
I'm out for the 4th, so it would need to be the 11th.
Mr. Fuel, April 11th, does that work for you?
1 second, Your Honor. Yes, the 11th will work just fine. Thank you.
Set that date for April 11th for presentation of the issues that were ruled upon here today. Appreciate everybody's assistance and input.
And Your Honor, I'm sorry to be what.
Go ahead.
Again, coming in late, who does the court want to be drafting this order?
We didn't necessarily have a moving party,
Right.
Correct? Because we have the guardian ad litem report. Either of you have a coin?
I'm fine to draft. I drafted the last order, so I'm fine.
Okay.
And no objection, Ms. Baldwin is good at this sort of thing, so I will look forward to receiving it.
Okay. Thank you, Ms. Baldwin. We'll see everybody on April 11th. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Pedersen and Pedersen matter next. That is cause 22-3396-08. There, Ms. Baldwin is representing Lacey Pedersen, and Mr. Fuel is representing Mr. Thomas Pedersen, and Ms. Height is the guardian ad litem. She's present. We have Mr. Pedersen present and Ms. Pedersen present. Welcome and good morning to all. We are on today for a presentation of a temporary parenting plan that was prepared by Ms. Baldwin. I'll just double check with the parties, see if you have any objections or concerns related to that parenting plan. Mr. Fuel?
Yeah, Your Honor, I do have about a handful that we'd like to go through with the court.
Okay, go ahead.
So, well, we do have local rules. They do require compliance. My concern is that he submitted a fairly lengthy list to me only on Friday via email. And Your Honor certainly doesn't have those before you. We have local rules for a reason. And it's important that we all engage in those rules. Gives me an opportunity to review them timely. If they're ones I agree with, make those changes. And if not, be prepared to be able to point out to Your Honor the record where you said X or Y. And so that's my concern, is that in this case, Mr. Fuel hasn't abided by our rules.
Okay. We were here last, I think, was it on the 21st of March? I think that was our last hearing date. And so we set it to today's date. So theoretically, that should have given everybody enough time to get the proposed order out and then submit objections and submit those to the court for review. I did review the order on its face, and I have a few items, and why don't I just review those, and that may address some of the issues that Mr. Fuel might have raised or Ms. Height may have raised. So let's just take a look on page 2 of the proposed plan under paragraph 4 on line 9, where it says 12 hours. I ruled that it should be 8 hours, so I'm just going to make that correction instead of 12, and I'll put in 8. And then on the next page, on page 3, which is the paragraph starting on line 3, where it says the petitioner is authorized to make all standard health care appointments, such as standard immunizations, well child checks, dental cleanings, basic care. The other party will be informed of any care that rises above this level. I ruled differently than that. I indicated that the mother would need to provide notice to the father of any routine or standard appointments or health care that was delivered. So that paragraph needs to be altered to reflect that. Then if you look later on in the document under page 10, this is under paragraph 13, under paragraph K1, where it says, I just had a question about meaning of this. It says on the second line, second sentence of paragraph K1, says it's regarding hair follicle or urinalysis. It says the request should be made in writing, by text message, or over the phone. I just didn't understand the language of or over the phone, what that was intended to be.
Just in the sense that you're using your phone to receive text messages. Your phone is where our family wizard is kept. Gotcha.
I was going to just remove that simply because it talks about in writing. So I was just going to remove that to remove any ambiguity of the idea that it might be like a voice communication.
That's fine.
And then under 13K5, there it says, if a drug test shows positive for alcohol use, then that party's visitation shall be immediately suspended until further order of the court. My concern with that one is that I think it needs to be amended to say something along the lines that says, if a drug test shows positive for alcohol use within 8 hours or during respondent's residential time, then the visitation shall immediately be suspended until further order of the court. Because the way it reads now, that a drug test could be had on a Monday and it shows alcohol for a Monday, and then there's no visit until maybe there's not going to be a Wednesday midweek, and there wouldn't be a visit until like the following So there doesn't really impact the parent's ability to parent during the residential time. And that was really the court's concern, was focusing on having a clear focus and clear mind during and before and during the time with the child. So under that 14 or probably 13K5, I was going to add that language after the word or phrase alcohol use, then include within 8 hours or during respondent's residential time. And that also applies to the K3 up above, where it indicates the test must be prepaid. Should the test show positive drug or alcohol use, then the party testing positive must reimburse the party who requested the test. I think it should be limited to testing positive within 8 hours of or during respondent's residential time. So I was going to make those changes. And then under 13L as in Larry, I was just going to change that from the 12 to the 8.
Very good.
So I don't know if that addressed any of the issues that Mr. Fuel that you had.
Well, all of those were on my list. There are a handful of things which don't match what the court ordered, but I suppose I'll leave it up to the court whether or not the court wants to hear that or not.
I think as a general rule, it's best for me to know what your objections are in writing. That way I can review them, think about them, review my notes, not necessarily on the fly, and then make the adjustments usually before even the docket starts, and then tell you where I'm at with that. If I need clarification, I would ask the parties for clarification.
Understood, Your Honor. Well, then I'd ask for an opportunity to file those with the court. I appreciate the fact that you've got rules, but again, there are a handful of things that don't reflect what the court ordered. So it's probably better to be accurate than fast.
Sure.
And then I have no objection other than fees. I'm here today. We had an opportunity to do this already. My client's here today. So I'd ask the court reserve on fees and address fees at the next hearing.
We can do that. We can reserve on fees. I'm not inclined to grant fees, but we can certainly reserve it and hear argument from the parties.
Perfect. Thank you, Your Honor.
So let me check with the parties. 1 week from today puts us at the 18th. So the objections could be filed. I can review those and then we can address it with the parties.
That's fine.
Will do. Thank you, Your Honor.
Ms. Height, does that work for you? I think you said yes.
You read my lips. Yes, thank you, Your Honor.
All right, very good. That sounds great. So we'll set over 1 week to the 18th for finalization of that parenting plan. All right, so we'll see everybody then.
Thank you, Your Honor.
Thomas Pedersen, Ms. Baldwin. Ms. Baldwin, I see that she is here also. Ms. Pedersen is here. Welcome. Ms. Height is here, and we're on for presentation. So it's kind of the second go around of presentation. I shared some thoughts from the first go. There's some objections that have been filed by Mr. Fuel. And so I think we should just kind of go look at those one by one and see where everybody stands. So bear with me one moment. Last time I indicated that on page 2, paragraph 4, the 8 hours should be 12 hours. I think that there was no concerns related to that. And then there was a request under page 2, paragraph 4, subsection 2, to strike on line 1314 the language that starts with, given this is a temporary order, counseling shall continue until terminated by the court. That was requested to be stricken. Ms. Baldwin?
So I think that's appropriate. The court did, I think through the GAL recommendation that was what he needed to do. It shouldn't be sort of a one and done situation. If he's going to terminate counseling, that should be either by agreement that everybody's acknowledges he's reached his treatment goal, or with court review.
Okay, thank you. Mr. Fuel?
Thank you, Your Honor. Our position was simply that it should be between the counselor and my client, rather than having us all have to come back to court if there's a dispute.
Ms. Height?
Your Honor, I agree that this can be decided between Mr. Peterson and his counselor.
Okay. All right, I'm going to strike the language. So it'll indicate this. Subsection 2 will read, engage in personal counseling with an emphasis on respecting boundaries as directed by the counselor. And they've stricken the rest of the language. I think that's appropriate. It feels odd to me that I'm the one that's telling the counselor when they're done. I think the counselor should be in the position to determine when the counseling is completed. Then taking a look And the next provision, that was on page 2. Next is on page 2, section 4.2, line 16. There's a request there to delete the word "and compliance." Mr. Fuel.
Yeah, Your Honor, obviously it's important that everyone have the information that my client is attending and participating. That's fine. Compliance, I feel like, gets into a little bit too much of the some of the privilege stuff that might be involved in some counseling. Again, I don't know for sure that that's necessarily implied or indicated by the phraseology of "and compliance." And so maybe if the court wants to massage that language, I'm just concerned that that turns into a little bit more information than just simply that my client is showing up as appropriate.
Okay, I'm going to leave that word in. I think that's appropriate to include that.
And I can report to the court, Olivia Lovely's office issues like a single page compliance sheet that just kind of tells you whether or not they're progressing in their treatment goal. So it's informative, but not that informative.
Yeah.
Thanks, counsel. Thank you. That's helpful information for me.
On page 3, section 4A, line 4, this is related to notification of healthcare appointments and the like. So I added my own language there. So this is what the order should read. Keep the first sentence, strike the second sentence, and then insert the language: petitioner must provide notice to respondent of all routine/standard healthcare appointments.
Do you ever have my amended order?
No.
Okay. So we
would
said,
be
no, that's
awesome
okay.
to have.
I amended that language to read, petitioner will give reasonable notice of any scheduled care.
That's fine. Yeah. Yeah. So I don't have that. That would be awesome. It would be a much cleaner copy.
Whatever it's worth, for the record, I have that. I have seen it.
Okay. And maybe what we could do as we're going through this, since I don't have that amended proposed order, that maybe a cleanup copy could be provided and we could sign off on it, and I'll just be much more presentable. Okay, great. We'll continue on. So I'm fine with that language that was proposed by Ms. Baldwin. Next is page 3, section 7B, line 23 and 25. To be a little more specific as far as the pickup times, Fridays noon or 2:30 as opposed to 6 p.m. and then the Wednesday 1:30 or when school is out instead of the 3:30. So I think the court indicated that it was. I'm not sure if I provided a specific time, so I'll turn to the parties for any recollection that you have.
I don't believe Your Honor orders specific time. The order generally is they pick up after school, and then there's a second sort of, but if there's no school, pick up at X. And so we have for weekends, pick up after school or 6 p.m. if no school. Really, that's going to apply in the summer. So I sort of set that after work. And then Wednesdays, pick up after school or 3:30 if there's no school until 6 p.m. that same day, since that's a little bit of a shorter visit. Backing it up to times that really don't correlate to school at all doesn't make sense to me. The request is to back up Fridays to noon. School doesn't release at noon. If it's an early release day, you can pick them up because it's after school. So the proposed language doesn't make sense. It doesn't comport with school at all. It's not really related. I think this is just sort of an odd land grab.
Okay, Mr. Fuel.
Well, and we'd argue it's an appropriate land grab to use the metaphor. Obviously, if there's no school, and as the court recalls, the evidence before it was that my client is flexible with his schedule. So I appreciate that, everyone wants as much time as possible with the kids. My client would simply like his time, if there is no school, to start as soon as possible on the day of his parenting time. And I guess we would roughly, and again, I don't have the kids' school times memorized, but for my conversations with my client, the attempt was to roughly match noon with the daycare time that would be appropriate for picking up, and 2:30 to be approximately when school would have otherwise been out. So, but I do appreciate counsel's take there that it is sort of a bit of a made up time there. So we would just simply ask the court to consider as much time as possible, and maybe Ms. Height has some input on that.
I don't have a strong opinion on either one, Your Honor. I understand the issues, and I think the parties should work it out in the best interest of the kids.
Okay, great, thanks. I'm going to leave the language as proposed. I'm going to leave that there. Then we take a look at page 4, section 9, lines 11 through 13. There's a proposal to basically, if it's a long weekend, whether it's the 3rd or the 5th, it would attach to that weekend. If I gather your gist, Mr. Fuel, that's what you're
Yeah, and your honor, it's specifically for July 4th. And this year's a great example. I believe that this year the 4th is a Tuesday. And so effectively what my client is asking is that thereafter, if the weekend of July 4th happens to functionally create a 3 or 4 day weekend, that in between day be made part of the holiday, so a little bit less back and forth between, days off in between a weekend and the holiday.
Thank you, Ms. Baldwin.
The language that's being proposed will absolutely cause problems and confusion. If your owner wants to back it up and just say July 3rd from X time to July 5th at Y time, I have no objection to that. But this sort of chaotic, well, if there's a 4-day weekend and then we're trusting the parties to be able to figure that out, it's just going to result in the parties having a disagreement later. So if you want to back up the time, that's fine. But I don't want it to be reliant on a 4-day weekend.
Okay. Ms. Height, any strong opinion?
I agree with Ms. Baldwin on this one. I think that makes a lot more sense. It's cleaner and easier to use in the future for every week that comes up. The one thing that comes up typically on July 4th weekends, as your honor knows, is the fun doesn't really start until late in the evening, usually on the 4th. And so it makes sense for the kids to be staying over on the 5th, since they're going to get to bed late, typically that night. So that would be my only input on that.
Okay, thanks. There's a lot of information to remember with parenting plans. There's a lot of details, a lot of minutia. So the easier I think we can make it for everybody, the better. So I'm going to back it up a little bit for the 4th of July and just changing the language from July 4th at 9 a.m. to July 3rd at 6 p.m. in both instances. So that allows additional time for the holiday, but it provides just a clear detail.
And just to clarify, your honor, were you indicating the return would be the 5th at 6 also?
No, the 5th at noon still. He just changed the start.
Okay, thank you.
Yeah, just the start time. Correct. Thank you. And then
Thank you, Ms. Baldwin.
Yeah, thanks. And then page 4, section 9, 16 through 21. This is winter break.
And I didn't have an objection. I did make that change.
Good. I didn't have objection to that either, so I made that change on my copy, but my copy doesn't really matter at this point. And then we'll look at page. There it is. Page 9 relates to the texting, basically, 13H3. So that's at the top of the page. So Mr. Fuel, any just brief comments on that, and Ms. Baldwin?
Yeah, your honor, I think that your order was that my client would be able to communicate with and initiate texts. I said the children, I guess it was really more with the older child, but as of the 1st of May. And so we were just hoping that language could be put in to this section, since it seemed to be about that same activity.
Okay, Ms. Baldwin?
Yeah, I don't have any objection. I guess I'm re-looking at my language. It's not clear that father can initiate as well. So I can just change that to either can initiate reasonable contact.
Under that H or subsection 3, it talks about calls. It makes mention of call at least on 4 occasions. Maybe there could be some language in there that indicates communication includes telephone calls, text messaging, just be a little more inclusive, because I think that was the intent.
Oh, sure.
Ms. Height?
I agree, your honor.
Okay. All right.
I don't want it to be in section 3 because you specifically, those are obligations of my client. So section 3 puts an obligation on my client. So okay. I don't want it to all of a sudden then lump that into the section 2 language that then my client's obligated to force the child to respond to every text. So, because then it can be read that way. So I would rather put language into section 2 that just is, that clarifies that father can initiate. And then in section 3, I don't mind being like calls or videos, but those are a different obligation than sort of can father initiate additional calls and texts.
So would you be comfortable if we just use the suggested language and move that to paragraph 2? That just
Yeah,
reads
that's
non.
fine. I don't mind. Yeah.
Okay, non-residential parent can communicate with and initiate text with the children.
Yep.
Okay, we'll include that in subsection 2, where it indicates any activities shall be posted to OFW. I'm disinclined to adopt that. I think both parties can contact the school and go to the websites and figure that out and get it. Just be proactive. And then, so I won't include that. On page 10, section 13K, there's a request to change it from 2 hours to 12 hours as far as the UAs based on work trips for fuel.
Yeah, Your Honor, I don't anticipate this being maybe a practical issue at all, but there is a possibility. My client does just have a little bit of work travel that he does, and it's certainly possible that if and when the request comes at exactly the wrong time, this would be a practical impossibility. And so if the court is uninclined or disinclined to extend from 2 to 12, we're flexible in some other kind of language that allows him a little bit of breathing room in case it's practically impossible for him to actually take a test and get that done within the 2 hours as drafted.
Okay, thank you.
Our concern here is specifically the court has made a prohibition about alcohol, and there was concerns about alcohol. If you increase it to 12 hours, there's no ability for my client to test at all. Then he has the ability to essentially sober up and then be sober before going to get the UA. And so here, if there's some kind of limited work trip, I think that he would have to give, if the court was to add language, then I would say leave the 2 hours, but you can add in if he's on a work trip, he has to provide like immediate notice upon the request that, hey, I'm in Idaho. And that my client then has the option to find a testing facility in Idaho.
And isn't this provision really getting at the time that the father spends with the child? The idea is that we want all parents to be as clear-headed and present as possible. Excluding substances helps parents to be more clear-headed during their residential time. And so if he's on a work trip, while it may be concerning that he's drinking alcohol, it doesn't directly affect the children because they're not in his care. So in my mind, if we include language that if he's on a work trip and has no residential time, because it talks about that later on as far as timing of when when an alcohol test shows positive. I don't know. So I guess I'm struggling a little bit as far as how to craft that. I'm open to suggestions. Ms. Haidt, if you have any ideas, I'm happy to hear from you too.
Your Honor, I am in favor of having a UA done within the 2 hour limit because I think that gives us the clearest picture. I also agree that if he's on a work trip, he's not going to be having contact with the children. Furthermore, I know that in my past conversations with Mr. Pedersen, he is very aware of making sure he stays within the boundaries that are laid out by the court. He wants to not violate those. So I can understand his concern of not being able to get someplace in 2 hours. I just don't think that that's a concern because of what you stated earlier. If he's out of town, he's not going to be around the kids. So I think leaving it as he needs to comply within 2 hours. I think that would cover the issue.
Maybe we could do this. The second line where it says failure to report within the allotted time shall be construed as a positive test unless respondent is on a verified business trip or something along those lines.
Yes, I think that would provide the safety that everybody's looking for.
Something maybe on a business trip and not engaged in or foreseeably engaged in residential time or something along those lines. So that allows for testing to be requested by the mother for the protection of the children, but allows him to carry on his business and without having to worry that he's going to get a positive test for not going.
That works.
Okay.
I think that makes sense, Your Honor. Thank you.
Okay. Then the next section is please add there will not be any reimbursement for any cannabis related positive tests.
Yeah, Your Honor, that was that came out of your mouth at the hearing. Obviously, again, the issue is the alcohol, and because cannabis specifically stays in the system significantly longer. That's what Your Honor had said.
True.
I don't have a recollection either way, and the clerk's minutes didn't reflect, so.
Yeah, if we could add that language, there will not be any reimbursement for any cannabis-related positive test. I'm fine with that. Page 10, there's a request to delete the language that starts, then that party's visitation shall be immediately suspended until further order of the court.
And so I amended this language to say that the party's visitation may immediately be addressed before the court on a shortened time basis.
And that addresses our concern, Your Honor. Thank you. Thank you, counsel.
Ms. Hyde, you comfortable with that?
Yes, Your Honor.
Okay, great. Thank you. And then page 10, section 13, L as in Larry, line 20. Also, this should say quote before or quote prior to having the children other than within.
I did change it to 8 hours. I don't think the word before makes a proper sentence.
Yeah, prior to.
I think you're probably right. Prior to, obviously, I think it's a little bit more precise. Obviously, the concern of within is that's a significantly different sort of concept than prior to.
Yeah, what do you think about the phrasing? Respondent shall not consume alcohol, non-prescribed drugs prior to.
I think it.
Or 8 hours prior to.
Yeah, if you put the prior to after, then my grammar is satisfied.
Our English teachers would be so proud.
Yeah.
It only took 4 of us.
Yeah, right. Right. Okay, so those are the ones that I had that were raised in the objections. Are there any others that we need to look at, or is that kind of Ms.
No,
Baldwin?
Your Honor. Thank you. I know that was an exhaustive list. I appreciate the court going through that.
Yeah, thank you. And then Ms. Baldwin, you'll produce that and.
Yes, I don't think we need another date though. I'll just produce that and circulate it to Ms. Hyde and Mr. Fuel.
That's
fine.
Ms. Hyde, any other issues on your end?
No, Your Honor, I think that's it. Thank you.
On May 3rd, 2023, they had a hearing on the trial setting docket to schedule their mandatory settlement conference, but I don't have a copy of that hearing. Their MSC was scheduled for September.
Mr. Thomas Pedersen, and both Ms. Pedersen and Mr. Pedersen are on the line today. We're on today for a motion. Mr. Pedersen's motions related to child support maintenance, the use of the home out at Lilywop, and attorney fees. So I've reviewed the pleadings that the party submitted, and let me just double check. There's also a proposed order that was signed by Ms. Baldwin. Looks like Mr. Fuel signed off on that also. So having that in my hands, I'll sign off on that. And then we can address the motion at hand unless there's any preliminary issues. Okay, great. So we'll hear from Mr. Fuel on behalf of Mr. Pedersen.
Yeah, thank you, Your Honor. So effectively, and I know the court's reviewed everything, so I won't belabor it too much, but the facts as they present today are pretty significantly different than they were at the previous support order. We're asking the court, now that the parties have been able to exchange a little bit more proper discovery, to effectively recalculate the child support using the incomes as we've presented them to the court today in the last handful of weeks, and also reassess the spousal support order as well. We asked the court to consider terminating spousal support completely at this point. Again, with the differences in the incomes as they present, I think it's there's a little bit more information that the court has now. That's updated and corrected from the previous order. Again, different numbers, so different orders, totally appropriate. I'd also point out that at this point, we do have about, I think 9 months to 10 months of spousal support that has been paid. It is only a 5-year marriage. I think that also weighs into a potential order for at least maybe an end date for spousal maintenance that doesn't necessarily require us going to trial and or going through settlement. And then in addition, I think we presented evidence in our documents regarding a modest change in the health insurance premiums as well. And then as far as the property, Your Honor, goes, yeah, this is a circumstance where there's no, because of the no contact order that is in effect, my client has some concerns about accessing the property. He certainly would like to be able to be there in some capacity without risking some sort of violation of that no contact order. Obviously, again, before there was parenting time, It certainly, maybe access was less of an issue, but now that my client's having pretty regular parenting time, it would be nice for him to have some, at least some sort of order that protects his ability to go to that property without, again, risk that mom might show up and then he would potentially be in violation of the protective order. He does have a very flexible schedule with his work, and so he does intend on using that property, presuming that the court makes some sort of accommodations for him. Again, just a real brief assessment of what we filed. I'm happy to answer any questions, so I can, Your Honor.
Thank you, Mr. Fuel. Is it Mr. Pedersen's intent to live there full time, or it's something less than?
Something less than, but Your Honor, he certainly, for example, because he is so flexible with his work, he had planned on, again, if available, to spend, like, for example, the majority of the summer months there, certainly, again, when he has more access and time to the children.
Okay, so the desire to spend time at that, he has the trailer, and he's wanted to take advantage of the summer months because he has a flexible work schedule. It's not so much that he wants to move out of his parents' home and kind of establish himself again, or how much does that enter into the equation?
Well, I think that is also the case, but I don't know that specifically is a linchpin issue on the use of the property.
Okay. All right. All right, that's helpful. Thank you. And I just wanted to recognize that Ms. Height is on the line also. Ms. Baldwin?
So thank you. In this matter, the court should look at the fact that the temporary order was signed in November. It's not that old. This is really just an attempt to relitigate the temporary order when there haven't been any substantial changes in anything. That's not reasonable to just repeatedly relitigate something. And you do that in part when you want to sort of siphon off the other party's ability to pay for the litigation, especially when we have a substantial difference in the incomes between these two parties. For us, the court to deny the motion and grant my client fees for responding to this. The arguments about wage increases, both parties received very modest wage increases from the last temporary order. Those are not unanticipated. And again, they're modest as to both parties. So it sort of puts both in the same position they were in at the temporary order. When you look at the respondent, he makes $14 more per hour than my client, $42 per hour and change. And that's not counting any overtime. That's not counting his side work that he gets 1099 for. And it doesn't include his side business. We calculated his income just at straight time and zero overtime at over $7,000 per month. He's gotten 1099s for an additional couple $100 per month. And then he has a side business where he's really not disclosing that whatsoever. There are records that would be available to him through Etsy and through Facebook, and he's not produced those to you to prove that he's not, that those aren't significant in income producing for him. So that puts him at $8,600 per month, and that's with no bonuses and no overtime whatsoever. But we know he does receive bonuses. Even his own materials show consistent bonuses from 2019 forward, and the statute's very clear that where there is a consistent bonus structure, that is included in income. So that also should be included in the Your Honor's thought process. When you look at the wage stub submitted, he's still contributing 8% of his income to his 401k. So sort of this claim of poverty doesn't match the fact that he's putting almost 10% of his income away. And again, when you look at the incomes of these people, my client's making just under $60,000 per year versus Mr. And again, sort of looking at the income that he's producing at about $92,000. So again, about double what my client's making. And again, that's without counting any of the side work or side business. Also important to note that the spousal support in this case is 100% funding the mortgage. So the spousal support is set at the mortgage cost. So not only is the spousal support that's supporting my client, but it's also preserving a community asset. So they're directly related and allowing the children to have stability. They asked for an increase in the offset due to medical payments. They provide zero evidence of that. It's just in his declaration. There's not a piece of documentation that says this is the breakdown for the child's cost versus Mr.'s cost versus the family cost. There's none of that. If they had produced that, then certainly an argument there, but without anything more, that argument just falls flat. So you can't just double that offset and say, oh, well, just give it to us. So again, not reasonable. Mr. has sort of at this point a standard every other weekend type plan. So again, there's no sort of deviation there. And again, there's really no significant changes. So this is just another bite of the apple on the finances. The court should maintain the current order. It's not reasonable to change it for where we are in the current process. As far as the Lilliwatt property, this is a property that's 2 hours away. It's a vacation property. He's not planning to live there. He just wants to visit there. He's paid not a dime for it since these parties separated. It's part of essentially a complex of properties that my client and her family own, essentially these adjoining lots. And so Mr. then wants to go and camp, then preventing my client from being there for her family and family activities. And again, all while he's not paying anything to use that property. So this isn't reasonable. My client says, hey, order it sold. Her family members have said, we'll buy it at sort of the going rate. I'm happy to do that to sort of resolve that off the plate. And that returns it to sort of her family who's owned it for 40 plus years. But otherwise, if the court's not ordering it to be sold at the offered price, then the court should maintain the property as to be used by my client. It's just not reasonable to order that Mr. can use this as a vacation property, then excluding my client from, her family's Memorial Day and 4th of July and other celebrations that they normally engage in, especially when there's a domestic violence protection order in place. There's plenty of other places that Mr. can go if he wants to take a trip. It's just not reasonable that he specifically wants to call out the property that adjoins her parents' property. So as the court to deny, either order the Lilliwatt property sold as requested, or the property is to remain in the use and possession of my client, at least at this point in the case. So with that, we're asking the court to deny the requests of the respondent and maintain the current financial orders, allow my client the use and possession of the Lilliwatt property. She's the only one who's paid for it since separation.
Thanks. Besides, do you have any comment? You may or may not.
I do not on this issue, Your Honor.
Thanks. Right, Mr. Fuel, any response?
Only that we'd rely on all the evidence that we provided about the changes in the income. I think that, again, using our numbers, my client's down over 1,000 per month. Wife is up almost 1,000. And so the difference there being 2,000 in these incomes, I think is rather, again, maybe significance obviously is up to the court to determine. We would say that given these incomes, those are relevant numbers and certainly supports the court considering a recalculation.
Thanks. Mr. Fuel, one question. Ms. Baldwin indicated that the insurance costs that was supported by declaration. Are there any other documentary or documents that substantiate the dollar amounts that are going out from his paycheck?
Well, I appreciate the question, Your Honor. First of all, obviously the declaration is evidence itself, and I appreciate the fact that we like to substantiate those things. Your Honor, I to be as square with the court as possible, I believe that that's the case. I don't have any in my possession, but I'm sure I can. If the court's considering a recalculation of any kind, perhaps the court would grant leave for my client to give me those documents so I could show them to Ms. Baldwin.
So I was looking at a submission on May 3rd, sold financial source documents, 56 pages. On page 6 of that, it's a pay summary for Mr. Pedersen from 2022, the year 2022, and it talks about deductions in the middle column. And it lists a vision. It shows a dollar amount, and then it lists some HRA 70 medical. It shows a dollar amount. Dental, there's a dollar amount there, and the like, and basic life insurance, dollar amounts associated. So I don't know if that was the basis of it, because I didn't do any calculations related to that.
You'd need the HR breakdown to be able to do the calculation. More than just the wage sub deduction is just going to show you the straight deduction for the total premium cost. But the child support inclusion is only the child's portion. And that just doesn't give you the information to be able to do that calculation.
Okay. All right. Thanks. All right. So with regard to the motion to basically adjust or modify the child support based on change of circumstances here, I think both parties both received raises. It was known that Mr. Pedersen had been receiving fairly regularly, not every year, a bonus, and it varied in dollar amounts. The average, I think, was 2.48% or something of that nature. Also, apparently, when the child support was initially set back in September or November, pardon me, any bonus structure from Ms. Pedersen wasn't clearly known. So I think there's a basis to move forward with the increased incomes of both parties and also new information related to bonus structure that's coming through to Ms. Pedersen. As far as the paid time off, to include that, I think that's kind of a double dip. It's income. If she wants to use it in vacation, do whatever she wants, she can do that. If she doesn't use it, then the money comes her way. So I'm not going to include that. As far as the incomes, I spent a lot of time with this yesterday, just working with numbers, and So this is what I can come up with. So I'm including the bonus structure for both parties in their incomes because I think it is fairly regular. It may not be every year, but I think it gives a fairly good approximation of what the parties are receiving. So I'm setting Ms. Pedersen's gross income at 5,178. That takes into account the bonus structure and spreading it out over 12 months. And again, as I indicated, I'm not including the paid time off in that calculation. So that's her at 5,178. As far as Mr. Pedersen's gross income, I'm including a bonus level of about 1,650, so about 138 a month. So his gross is at 88,149 plus that 1,650. So that sets him at 7,483 gross. So that's where I'm setting him at that. I'm inclined to give him credit for the insurance premiums, but I don't think there's a basis to do so. So I'll hold off on that. I'm also not taking into account the pavers business. He may be rocking it with those pavers, with those positive reviews, and I don't know. I don't know what his income is on that, so I'm not taking that into account. I just think at this point it's too early. We don't have enough records, and it's almost speculative, at least from my vantage point, to make a decision on that. As far as the independent contractor income, there was a representation that was used to pay down debt. I'm not going to include it at this time. It may come back later to be included, but for now, I'm not including it. So that sets those incomes at those levels with the proper deductions. And then that leads us to the discussion of spousal maintenance. So I guess when I'm looking at the spousal maintenance, there was I think that the dollar figures are fairly clear of what each party is receiving. It looks like both parties have been in their jobs for a number of years. They're fairly well established. They're getting regular raises. And so I guess kind of the question that came to my mind is what is, obviously I take into account the standard of living, the length of the relationship and the marriage, the any training or specialized education needs that need to occur. So I take all that into account. It seems that Ms. Pedersen's not in a position where she's needing extra training. She's in a good career with a solid future. And then I also take into account the ability to pay and the need. Clearly, there's a difference of income about, as Ms. Baldwin indicated, about $14 per hour difference. There's also an indication that Mr. Pedersen is paying for right now the full weight of the mortgage, basically, plus his truck. Ms. Pedersen, her car's getting older; it's in excess of 100,000 miles, and Mr. Pedersen represents that he's still living with his father. So, as far as setting an end date to the maintenance, I'm going to refrain from doing that, but I am going to reduce the maintenance to $1,200 per month. And I think that's a nod to the fact that that he's living in his folks' place. If he has the trailer, if he wanted to rent a space, he could move out and rent a space, probably about $500. So I'm going to reduce that. So that'll be taken into account in the child support calculation. The vacation lot in Lilywop, I think that's fraught with issues. Just given the history of the case, and I recognize there's dispute on what did or didn't happen. I think that allowing Mr. Pedersen to use that would be premature at this point, and it's just not proper. It'd be inappropriate based on the past experiences that have been occasioned within the marriage. So I'm not going to allow that. And so Ms. Pedersen will continue to have options to use that. She's paying for it and the like. So she'll continue to take care of the taxes, utilities, and the like. And I'm refraining. I'm not going to order that it be sold. I think it's just premature at this time. The setting of it and the fact that there's kind of this familial connection to the land, and Mr. and Ms. Pedersen being the owners of the land, I think that we need to definitely have some type of a third-party evaluation on the value before there can be any arm's length deal. So I'm going to hold off on that. So that's the court's decision. And I'm refraining from imposing any attorney fees, so I'll deny that request. So with that said, any points of clarification needed from the parties?
I don't believe so. We don't dispute, and it should be included, that Mr. would receive a credit of $142. That was proved at the last hearing, and so that would be appropriate too.
For the insurance cost?
Yes.
Okay. All right. Thanks. Mr. Field, do you have any points of clarification?
No, Your Honor, although if, as I mentioned before, if we can provide updated numbers that are satisfactory to Ms. Baldwin, the court will allow us to put that corrected agreed number in.
Sure. I mean, if there's agreement between the parties, that's fine. I'm inclined, if those are costs that are regularly deducted from child support, because it is child support, because it's going to the benefit of the children. So if the parties can agree on that, and there's documentation, I'm fine to sign off on that.
Thank you.
All right. With that, any additional items?
No, just setting for presentation. I'm potentially in trial. I'll find out later today on the 13th. On the 20th, I'm trying not to be here. So I'd ask either we set tentatively to next week or the 27th.
Any preference, Mr. Fuel?
Yeah, 13th would be much better for me. I'm also not going to be available on the 20th and potentially not available on the 27th either. And then I know we've got the 4th, I think, the following Tuesday.
Okay, let's go ahead and shoot for the 13th then.
Let's do that. We'll set it for presentation next week, June 13th at 9 a.m. As far as the change in the spousal maintenance payment, I don't recall the specific date that it was being paid or that it was due. Do the parties recall the timing of that?
I think it's half and half, like half by the 5th, half by the 20th.
And 5th and the 20th or something like that. Okay, so let's have this be effective as of today. So the next payment would be the reduced level.
Okay.
Thank you, Your Honor.
Great. All right, with that, thanks to the parties.
00396-08 Peterson v. Peterson. I see Ms. Baldwin and Mr. Fuel. Let's see, Ann Height. Okay.
Just before we begin, I noticed in the court file a reply declaration filed on behalf of Thomas Peterson. Mr. Fuel, could you indicate to me how that was served upon my office?
Yeah, that was only via email at this point. I know that I need to get a hard copy too. Your Honor, we're going to ask actually if we can kick this over a week. My client would feel more comfortable if Judge Evans was hearing this matter.
And I would absolutely contest that. There's no reason. I prepared for this hearing. I did not receive the reply declaration via email. I had my staff check. I checked. So I only found it this morning, but I got ready to go forward today, regardless, because there's nothing I can do to respond to a reply. Your Honor heard this case back in the fall, so it's appropriate that you hear it again. So anything other than that is sort of just, again, making my client sit through a docket, having me prep for it, and then saying, oh, I'd like to kick it over now. So we should go forward.
And it's only been 12 minutes and it is our motion.
Okay. So I think you have a right to set it over, but at the same time, for setting it over without any notice, I am looking at terms if that's going to be granted. So as long as that's understood.
Understood.
All right. So I will grant $500 in terms for the necessity of having prepping for today. Additional attorney's fees can be requested at the time. So I'll set this over to June 6th at 9 a.m.
Thank you, Your Honor.
Very good.
They returned the following week for Dad's motion, but I don't have a copy of that hearing, and Odyssey doesn't say anything about what Dad's motion was about, just that the judge ruled on it.
Move to the Lacey Pedersen and Thomas Pedersen matter. This is cause number 22-3-39608. We should have Ms. Baldwin on the line and also Mr. Fuel on the line and Ms. Hyde on the line, along with possible clients. Ms. Pedersen is here. Lacey Pedersen is present. And I'm looking for Thomas Pedersen. I don't see him on today.
That's correct, Your Honor. I indicated to him that since we were going to be agreeing to these orders, that there probably was not going to be a lot happening.
Okay, so it sounds like Mr. Fuel indicated via email to all parties and to the court this morning that they're agreeing with Ms. Baldwin's orders that you submitted to the court, and I have a fresh copy of those orders in my hand this morning. So I'll sign those unless anybody wants to talk at length about anything.
Not this morning, Your Honor.
Okay, great. Ms. Baldwin?
No, Your Honor. Thank you.
Great. I will sign those and we'll get those filed.
Great.
Very
Thanks,
good.
counsel.
Thank you.
The next time they were in court was 3 months later when they had their mandatory settlement conference. MSCs are not streamed, so I don't have a copy of that hearing. But we can see from Odyssey that they did not come to an agreement, so they're going to need to schedule a trial.
And then number 10, I think I have Ms. Baldwin on Lacey Pedersen, Thomas Pedersen. I think it's Mr. Fuel.
That's correct.
Okay. And we have Ann Height guarding ad litem on this. My notes show set for 1 day non-jury trial.
I think it's 2, realistically.
I think 2. Okay.
Better safe, I think, probably.
Okay.
I'd be looking, looks like first sets are a ways out, probably in the summer then.
For a civil priority.
Yeah.
Okay.
Can't do June, but I can do July.
Okay, we could do the week of July 1st.
Okay.
Week of July 1st with trial readiness on June 25th at 11:30.
Is the 5th a court day?
Fifth is.
Yeah, we will be open that day.
Okay. Hopefully we won't be there, but okay. Yeah, that looks like it should work. Thank you.
The trial was scheduled for 7 months later in July of 2024, but it was canceled at their readiness hearing on June 25, 2024, a month before the trial was due to start, and they were sent back to the trial setting docket to schedule a new date. They're given a new trial date of September 5th, but at the readiness hearing in August, the trial is canceled, and they are sent back yet again to the trial setting docket.
All right, number 1 on the docket, 22-3-00396-08 Peterson v. Peterson. We have Ms. Baldwin. We have Chance Fuel. Is that how you say it?
Fuel, yes, ma'am.
Okay. And this is to set a new trial date for a 2-day trial. And I don't know if we have Ann Height. I don't see Ann Height.
No.
But
We're not expecting her. She did give her unavailable dates though.
okay. All right. So how far out are you thinking at this point?
We're ready. We were ready to go, and unfortunately, Mr. Fuel caught COVID, and that canceled our trial. So
Okay.
we're 100% ready to go.
Okay. All right. Let's see what we have. 2 days.
Okay, let's see. How about the week of October 14th?
That's not gonna work for me. I currently have one scheduled for the week before, so I don't think doing them back to back would be realistic.
How about the week of October 28th?
Yeah, let's that I can make that work.
Yeah, I would have a conflict on the Wednesday, but if we can, maybe what we did last time was kind of earmark maybe Thursday and Friday. Is that possible? I know that we kind of have to see what happens, but that week we can maneuver it.
Yeah, I would just bring that up at the readiness to
Yeah.
try to get that Thursday, Friday.
Thank you, Your Honor.
All right.
And readiness will be October 22nd at 11:30.
Yes, very good.
Okay, thank you.
Thank you.
Right. All right, going to number 2 on the docket, 22-3-00517-08 Monday and Monday matter. We have Ms. Baldwin, we have Mr. Fuel. This is to set a 1-day trial on this matter. How far out are you thinking?
At least into January.
Yeah, just for the record, and Ms. Baldwin, I'm sure knows this, but we Mr. Baldwin and I yesterday made some significant progress on our linchpin issue. So I think that there's probably a pretty decent shot that we don't even need to try this thing. But I agree, kicking it out a decent amount of time so we can resolve. It's a realist the marital property issue, and once that gets settled, I think we're probably all right. So January or even February.
Yeah, that's fine. Just no earlier than January.
Agreed.
How about the week of January 20th?
I'd be available.
Yes, that'll work.
Okay.
And then readiness will be January 14th at 11:30.
Okay, thank you.
Very good. Thank you.
Thank you.
A month later, on October 22nd, they had their readiness hearing, but the trial was canceled for a third time. On October 30th, 2024, they make a fourth attempt to set a trial date. They've been trying to have this trial for over a year at this point. The new trial is scheduled for February 17th, 2025. But in January 2025, a month before they were set to go to trial, there was a stipulation, meaning an agreement by both parties, that both sides would waive their rights and enter into binding arbitration, also known as a binding settlement conference, instead of proceeding to trial. A mandatory settlement conference and a binding settlement conference are basically the same thing, with one main difference. In a BSC, you're agreeing in advance to allow a neutral third party to make the final decision on anything that you cannot come to an agreement on, and you're not allowed to change your mind afterwards. An MSC is non-binding, which means if the parties still cannot agree after the MSC, then they can schedule a trial to have a judge hear the case. At a BSC, both parties have agreed to allow the mediator to decide what is best if they are unable to, and the mediator's rulings will become the court order. There is no option to have a trial if a party doesn't agree. They've waived that right. On February 26, 2025, the arbiter's decision was uploaded to Odyssey, but there's no information to tell us what was decided. The upcoming trial was, of course, canceled too due to the BSC. In March and April, there were 3 attempts to have a presentation of orders hearing, with 2 being continued and a third struck. My guess is that Judge Evans needed to hear it, but he's not normally scheduled on this docket anymore. They must have managed to get the documents sent to Judge Evans, though, since he signed off on all of their final orders on the same day as the hearing that was struck in April. He signed all the regular orders, including a decree of dissolution, and that dissolution included a judgment. There are actually 2 judgments showing in Odyssey on that date. Both are judgments against Dad for money he's required to pay to Mom. The first one is for $12,426 for her share of their marital property. In the second, Dad was ordered to pay $7,500 towards Mom's attorney fees. The final entries in Odyssey confirm that the case was settled without the need of a trial, and it ends with the withdrawal of the attorneys. They have not returned to court since. Thanks so much for watching.